Good afternoon, colleagues. I would like to start the afternoon meeting, so I ask for silence, please. First point on our agenda for the afternoon is the presentation of the draft report on the electronic mass surveillance of EU citizens, Rapporteur being Mr. Moraes. I will give the floor first to the Rapporteur. Please, Mr. Moraes.
Thank you very much, Chair. Sorry, I'm just having a sip of water. Thank you very much, Kinga, and thank you, colleagues, for your attendance. I realise this is a Thursday afternoon and we're making a presentation of the main report today, but thank you for your attendance, and I know this is web streamed, and I know other colleagues will read the report in due course. I want to first of all begin with a thank you to all the various colleagues who have put together their working documents, which has enabled me to present today the main report of the Committee of Inquiry into mass surveillance. This has been a very difficult and challenging task, Chair, which has lasted over, or is going to last over a period of approximately 6 months. A very challenging task, mainly into allegations emanating from the allegations of Mr. Snowden, but also in the context, a very important context here within the European Union, of our own developments, most notably our own developments on the data protection regulation and the context in which we ourselves in the European Union were making advances on very important key elements of our own advances on privacy. So it was very important for us in this last 6 months to put together an inquiry, and I'm very happy that our Secretariat has worked very hard in a very short space of time to put together a range of witnesses, which has enabled us now to assemble a report together with these key working documents and enabled me to put together a draft which I'm going to present to you today. The working draft on mass surveillance really results in 3 elements. First of all, 18 main findings, and then a set of recommendations and a priority plan. It's very important, first of all, in relating to the main findings, that we had a set of witnesses in our inquiry, and in the inquiry where we saw a whole set of witnesses ranging from journalists to whistleblowers to parliamentary scrutiny committees to technical experts, that we were not a court of law or a forensic body, but we were assembling, in a sense, evidence, primary evidence, secondary evidence, but essentially circumstantial evidence, where we were trying to build a picture. As any national parliamentary inquiry would do, we as a European parliamentary inquiry were trying to build a picture around a set of allegations made by Edward Snowden and trying to make sense of what was going on. We were also tasked in this inquiry with bringing forward a set of recommendations about the future, about what we would say about the way intelligence services were operating, the way that data was being collected on citizens, and how mass surveillance was being operated within the European Union. We were looking at our relationship in relation to data between the European Union and the United States, and we were also looking at the future. How would privacy operate in relation to the European Union and our relationship with the United States for the future? So the findings were built, and the 18 findings in this report were built on the evidence we took from the inquiry and on the various sources that we built during the process of the inquiry. The recommendations and the priority plan were then built on those findings. And in looking at the recommendations, we built not just on the inquiry itself, but on the substantial expertise of members across this House who, I have to emphasise, worked on the issue of data and privacy for many, many months, indeed years, before this inquiry even began. So on the issues of passenger name records, on the issue of SWIFT, on the issue of safe harbour, all of these key names that people are so familiar with, these were issues, of course, which parliamentarians here present were working on well before this inquiry. This is a mature parliament when it comes to the issue of data protection and privacy. And this is very important because this takes this parliament over and above, in my view, the way that national parliaments were looking at this issue. We, in a sense, should be looking at this issue in the way that we have competence on many areas of data privacy because we were already working in these areas. And of course, the central area that we were working on in relation to Mr. Albrecht's report, the Data Protection Regulation, and of course the Data Protection Directive, meant that the timing was extremely important. We were working on the major piece of international legislation in this area while these allegations were being made. So I expect that colleagues will, in time, if they have not already, looked at this draft report, looked at the 18 main findings and recommendations. I should also mention that my colleagues in the Foreign Affairs Committee looked at this whole area of the EU and US and the building of and rebuilding of trust between the European Union and the United States. But when my colleagues here present and those who are not here look at the recommendations and the priority plan, which I'm now going to go into in more detail, they should do so not as a national parliament would do, but in a sense that we as a European Parliament are looking to the future. It's up to us in this European Parliament to have some settlement on the issue of privacy. And I think the first thing I will do, therefore, is to concentrate my next comments on the recommendations, because there I think the report is most relevant and it takes a lot from the working documents of my colleagues. And I want to immediately go to those recommendations and refer as well to those working documents. And let me first of all point to the recommendations, which I think will elicit most from the way that the narrative of this report has been written. The recommendations are pointing to where we want to take the future of our privacy. In a sense, we want to build a kind of European habeas corpus. If excuse me 1 second, I'm just going to refer to our recommendations. The first recommendation is on the question of safe harbour. The report reiterates the message from the working document of Mr. Axel Voss, which called on the Commission to suspend the safe harbour principles, which allows US companies to transfer the data of EU citizens to the US while providing an adequate level of protection. On the TFTP, in accordance with the Parliament resolution, the draft report calls for suspension of the current TFTP agreement until the conditions as laid out in our resolution have been met. For example, while Commissioner Malmström concluded that there had been no breach of the TFTP after a consultation procedure with the US, this conclusion is not only based on assurances by the US, and we would ask that a thorough investigation is continued with our US partners in the name of rebuilding trust in the agreement. And here I also want to mention that my colleagues Sophie in 't Veld and Cornelia Ernst have done a lot of work in their working documents on our relationship with the United States and on the issue of oversight mechanisms. It is absolutely important that in the report We've looked at the value of oversight mechanisms, the way that we look at how we regard the way that the allegations have shed light on our relationships and how we have to rebuild trust in this area. On EU data protection reform, the report specifically calls on the Council to begin work on the data protection package so that an agreement is reached by 2014 at the latest. In addition, it reiterates the importance of both the regulation and the directive being adopted as a package. The Parliament have already sent a strong message on this under the rapporteurship of Jan Albrecht, so it is for the Council to now start working on it immediately. The EU-US Data Protection Framework Agreement, the Umbrella Agreement, this is vital, and we welcome the Commission's aim of adopting this agreement by spring 2014. The main importance of this is to provide judicial redress for EU citizens. We've made this very clear during the inquiry to our US counterparts, and the key point is that in the issue of mass surveillance, we are here for the protection of our EU citizens, and that is the message that we want to send clearly. At the moment, EU citizens simply do not enjoy full and reciprocal judicial redress rights as in the US courts, as guaranteed only to US persons. On top of this, completing the negotiations would restore trust in transatlantic data transfers. On TTIP, of course, the draft report recognises the major importance of TTIP for economic and job growth for both the EU and US. However, we've strongly underlined that in building this trust, we have to ensure that strong data privacy protections are achieved separately from the TTIP for obvious reasons. On EU cloud computing, the report also recognises the importance of a swift development of an EU cloud as it ensures protections for EU citizens' data, given that any data they store in the cloud of US companies can potentially be accessed by the NSA. An EU cloud could ensure that businesses apply the high standards of EU data protection rules. In addition, one positive aspect of these disclosures is the potential economic advantage that it may protect, that it may bring EU businesses. On journalists and whistleblowing, throughout the inquiry, the LIBE Committee had heard several statements by journalists, whistleblowers and civil society on the need for strong protection of freedom of information and from civil society on the need for strong protection in the sensitive area of intelligence activities. Furthermore, from key journalists, including people like Alan Rusbridger of The Guardian, we saw reactions to disclosures from Edward Snowden that were quoted as having a chilling effect. The report calls for the Commission to issue a comprehensive report on whistleblowers to include the field of security. On IT security, the Snowden disclosures I believe, have exposed a huge weakness in the IT security of EU institutions. This was further highlighted by the reports last month by a French newspaper when a hacker was able, some weeks ago, when a hacker was able to access MEP and staff email without much effort. It is clear that there is a security problem in the EU institutions. As I mentioned earlier, we need to rebuild trust between the EU and US, and here we have a number of paragraphs within the report from our colleagues within the Foreign Affairs Committee and from colleagues within the LIBE Committee. And we've had a number of interactions with our colleagues in Congress. Here it is clear that it is not just a question of diplomacy, but of understanding that we must have interactions which lead to concrete actions. And the recent review by the White House and our continual monitoring of court actions and federal court actions in the United States and our continual interest in developments there are very important for the EU. I want to finally talk about the, excuse me just one second, in conclusion. Finally, colleagues, I want to just say that the The narrative of this report is that we want to look to the future and we want to ensure that, in conclusion, that this is a report which doesn't just evaporate as soon as this mandate is over. And Chair, if I could just say this in conclusion, we want to ensure that this report lasts into the next mandate and is a blueprint for institutions for the next mandate. In that sense, I'm calling in this report for the EU institutions and member states to support and promote a sort of European digital habeas corpus, to commit ourselves to act as an EU citizens' rights watchdog with a timetable to monitor implementation. I've set out on page 33 a proposed timetable where we can monitor the kinds of recommendations that we've made in the report, so that this report is not some static report which is just then put on a shelf, but that we have a way of following it up. And in that sense, I want it to be a dynamic document that reaches into the next mandate, that ensures that it's not just the type of report that would happen in a national legislature, but dips into the rich privacy knowledge that we've had in this Parliament and is a dynamic document. Thank you very much.
Thank you, Mr. Moraes. Now I would give the floor to all the shadow rapporteurs, but I have to ask for your permission because I have a colleague from AFET, Mr. Salafranca, who has to leave, as I've heard. So if you agree, I will give the floor to our colleague from AFET on this issue and then start the round of the shadow rapporteurs. Do you agree with that? Okay, then, Mr. Salafranca.
Gracias, señora presidenta. Gracias a los ponentes en la sombra. Efectivamente, tengo que tomar un avión a las 3 y voy a ser muy breve. Simplemente quisiera agradecer al ponente, señor Moraes, la excelente cooperación que hemos mantenido. Hemos visto que en su proyecto de informe hay 16 párrafos que conciernen más directamente a las responsabilidades y al ámbito de la política exterior, y él se ha ceñido con bastante fidelidad a los términos del documento de trabajo que con los otros dos coordinadores de la Comisión de Asuntos Exteriores hemos presentado. Sin embargo, hay algunos aspectos que son susceptibles de mejorar porque el informe tiene 50 considerandos, 116 párrafos, es un informe ambicioso, amplio, como requiere la importante materia que estamos abordando, y por lo tanto creo que hay algunos aspectos que son susceptibles de mejorar. Uno de ellos creo que sería importante el poner el acento en reforzar la importancia que tiene la lucha y la cooperación antiterrorista con los Estados Unidos para las dos regiones, y creo que ese aspecto es susceptible de ser mejorado. Hay otros párrafos, son muy pocos, voy a referirme a ellos rápidamente. En primer lugar, quisiera hacer una referencia al párrafo 6, que creo que podría ser mejor orientado desde el punto de vista de sus consecuencias prácticas. El párrafo número 9, cuando se dice, cito en inglés, la condemnation in strongest possible terms, evidentemente todos hemos dicho que estas actividades son absolutamente rechazables, pero quiero recordar a los colegas que los términos de las resoluciones que adopta el Parlamento Europeo solemos reservar estos calificativos para los crímenes en masa, los crímenes contra la humanidad, y por lo tanto quizás podríamos encontrar una fórmula que, respetando el espíritu, fuese más coherente con las aseveraciones que queremos poner encima de la mesa. Evidentemente, el párrafo 59 es un párrafo muy sensible. Yo he sido de los que he trasladado con otros colegas a los miembros de la Cámara de Diputados y del Senado de los Estados Unidos que en las presentes circunstancias y habida cuenta de estas actividades rechazables, insisto, el Parlamento Europeo no estaría en medida de ratificar las negociaciones del Acuerdo de Comercio e Inversión, y creo que este punto es un punto sensible y que podríamos encontrar también una fórmula que, respetando la sensibilidad que plantea, podamos formularlo en términos más razonables. En todo caso, y termino ya, señora presidenta, quiero agradecer nuevamente al ponente su sensibilidad, su comprensión, su apertura de miras, y espero que esta excelente cooperación que hemos venido manteniendo desde la Comisión de Asuntos Exteriores pueda seguir produciéndose en las últimas fases del informe, en lo que se refiere a la presentación y valoración de enmiendas y voto. Muchísimas gracias.
Thank you very much, Mr. Salafranca. And then we turn to the round of shadow rapporteurs. Mr. Voss, please.
Vielen Dank, Frau Vorsitzende. Zunächst möchte ich mich auch bei dem Berichterstatter bedanken. Ich finde, der Bericht ist eine sehr gute Grundlage. Er ist gut, er ist etwas auch mit dem Hinweis darauf, dass wir das weiter beobachten sollten. Ein richtiger Anspruch, den wir als Parlament erheben sollten. Er ist breit angelegt, deckt viele Dinge ab und berücksichtigt auch verschiedene Aspekte, die hier in diesem Umfeld mit aufgekommen sind. Und von daher, glaube ich, haben wir dort eine wirklich gute Grundlage geschaffen, was die Bewertung der ganzen Massenausspähung auch betrifft. Wenn wir uns die Ziele einmal angucken, mit denen wir hier auch uns hervortun wollen, wir müssen zum einen das Vertrauen wiederherstellen in eine Kommunikation der Zukunft. Wir brauchen das Vertrauen aber auch in der transatlantischen Freundschaft. Wir müssen den Verlust über die Kontrolle auch unserer Daten versuchen wieder auszugleichen. Und ganz generell müssen wir auch unsere Kommunikation in Europa auch sicherer machen. Die Privatsphäre der Bürgerinnen und Bürger entsprechend schützen, aber auch die technologische Infrastruktur Europas gegen Cyberattacken, gegen Ausspähung auch sichern und letztlich aber auch die europäischen Institutionen um einiges besser absichern gegen oder schützen gegen die Ausspähung als solche. Dazu brauchen wir, was jetzt bestimmte internationale Abkommen auch betrifft, dieses sogenannte Anti-Spy-Abkommen, worüber man durchaus ja diskutieren kann, ob das nachher so zielführend ist. Aber ich denke schon, dass wir auf jeden Fall dieses Umbrella-Abkommen entsprechend brauchen. Und das wurde auch in dem Bericht entsprechend zugrunde gelegt, auch gefordert. Und das ist auch gut so. Der Safe-Harbor-Mechanismus, der meines Erachtens bei den Bürgern viel beeinträchtigender ist als all das andere, dass wir hier auch zu, ich hoffe, einer Übereinkunft kommen, dass wir dies auch aufheben wollen und gegebenenfalls auch an die technischen Entwicklungen nachher anpassen. Dass wir keine Wirtschaftsspionage wollen, ist richtig. Und dass wir uns aber auch konzentrieren sollten, wie wir eigentlich geheimdienstliche Tätigkeit in der Zukunft organisieren möchten. Dazu ist zum einen notwendig, dass wir unsere Abwehr auf der mitgliedstaatlichen Ebene stärken, dass wir unsere Abwehr aber auch auf institutioneller Ebene stärken und wir letztlich auch vielleicht eine Basis dafür schaffen sollten, dass wir eine gemeinsame Abwehr mit den Partnern und möglicherweise dann eben auch den Partnern aus Drittstaaten zusammen schaffen. Wie immer man das nachher formulieren kann. Wir brauchen, und das halte ich für besonders wichtig, da wir bislang keine entsprechenden Zeichen auch von der atlantischen Seite bekommen haben. Wir brauchen meines Erachtens eine technologische oder bessere technologische Unabhängigkeit Europas. Und dafür müssen wir um einiges mehr tun. Es wurde zwar die Cloud schon entsprechend angesprochen. Wir müssen sehen, dass wir aber vielleicht auch die Verbindungsdaten oder das Routing anders gestalten und kryptologische Elemente hier auch noch mehr verwenden hinsichtlich der Sicherheitsstrukturen in der EU, dass wir dort aber uns auch überlegen, ob wir nicht bei Europol das Cyber Center besser stärken sollten und ob wir nicht bei ENISA habe ich das Gefühl, beschäftigt sich nicht mit den richtigen Dingen. Wir sollten ENISA besser aufwerten und möglicherweise auch hier an den Standort holen, wenn wir ENISA mit der Aufgabe versehen, auch die europäischen Institutionen etwas sicherer zu machen. Darüber hinaus gibt es, ich will es auch gar nicht zu lang machen, gibt es auch Elemente, wo wir gucken sollten, wie wir im Beschaffungswesen vielleicht auch besser vorangehen, was Hardware und Software betrifft, generell in Europa und vielleicht auch gucken, wie wir manche Vergabe von Aufträgen im sensiblen Bereich auch hier nochmal vielleicht besser angehen können. Aber das sind meine Anregungen und dadurch, dass ich auch gleich weg muss, werde ich leider denn die Antwort nicht weiter hören können. Aber generell ein großes Lob für diesen Bericht.
Danke, Herr Voss. Mrs. Intveld.
Yes, thank you, Chair, and thanks to the Rapporteur and to my colleagues, the shadows, for the document that's before us. I think it is it's an excellent, a very comprehensive package, and I'd like to start by saying that I'm actually very pleased and proud to be a member of this European Parliament, because we seem to be the only institution that's really doing this kind of job in Europe. First of all, regarding the procedure, I agree with the Rapporteur that these recommendations should be, let's say, adopted as a kind of package that we then leave as a legacy to the next European Parliament for implementation. With regard to data protection, you rightfully say that that's been on the agenda for many, many years. It's nothing new, but it's all the more urgent now that the package is adopted, and that a package is adopted that meets the standards that have been set out by the European Parliament. And in this respect, I find it worrying and actually quite shocking that the Member States, despite all the revelations, are still seeking to water down the data protection package. I won't say very much about the recommendations on oversight over the activities of intelligence services, because we've been discussing that when we were presenting our working document. Then I think it's also very important to look at the issue of enforcement, because it's not all about new legislation. For example, we have good data protection legislation in place. It may be a bit, it may be in need of updating, but it's there. And I'm pretty sure that all these mass surveillance activities are a violation of the existing laws. So we would expect the governments, the national governments or the national authorities and the European Commission to be a bit or a lot more strict in enforcing the rules. Because if we adopt new legislation and again it's not enforced, then what's the point? If we accept that our own rules, our own laws are being overruled by laws from a third country, any third country, then why bother passing legislation in the first place? Then we've got better things to do. And this, for example, in this respect, I would also like to refer to the non-investigation by the Member States and by Europol into the alleged break-in to the SWIFT service in the Netherlands. And I'm very glad that the Working Party 29 decided to or it's actually, I believe, the Dutch and the Belgian authorities who are conducting a joint inquiry. And I think we should follow very closely what they are doing and try and include their conclusions in our report if that's possible. I'd also like to remind colleagues that this House, in adopting a report of mine 2 years ago, has called for an in-depth evaluation of counterterrorism policies, and I believe that becomes topical and relevant again against the backdrop of everything we know now. I think it may be in here somewhere, Mr. Rapporteur, but then I've overlooked it, but I think we should definitely recommend that at the next revision of the EU treaties, powers should be created for the European Parliament to conduct a full parliamentary inquiry. We should have the power to summons witnesses and to hear them under oath. We should have more powers to conduct a full parliamentary inquiry. I also think we should look at the at transparency and access to documents as the kind of part of checks and balances which are vital to a healthy democracy. And it's very, very worrying that the talks on the revision of the transparency regulation are still blocked. Investing in IT security, I think, is going to be a very important part of all the recommendations, because if one thing has become clear to me, at least, in the past months, it's that we've been very naive, that the first thing we should do is invest in the security of our systems, to begin with the systems of this House. And, you know, we've asked questions, and sorry? The replies are expected next week. Oh, well, if there are any hackers out there, you've got until next week, you know, you better hurry up. I mean, there's still printed notices up on the walls in this building saying the Wi-Fi is down. This is a joke. This is a joke. You know, maybe we should, instead of putting up notices saying the Wi-Fi is down, we should send out invitations to people, not only hackers, but cyber criminals and what have you, saying, you know, the doors are open. Yes, no, but seriously, and I also think that you know, there are people here, civil servants, highly paid civil servants, who are responsible for the security of this system. And I don't think it's good enough that we get a reply 2 months after the alleged break-in. I mean, if this were a company, the persons would be out on the streets by now. They would have been sacked. Why is it that we tolerate that we don't get a reply to this and our system is still not secure? Can anybody explain that to me? Because I fail to understand, but that's probably my fault. 2 final remarks. One on EU cloud computing. I'm very much in favor of encouraging our own European capacity. I'm not in favor of putting a fence around a European internet or something like that. This is not about protectionism. This is about boosting our own industries and our own capacities, and make sure that citizens, first of all, have a choice, and secondly, that companies have an incentive for building stronger and better protected systems. I think the remark of, I cannot remember the name of the German gentleman we had here, the German, let's say, hacker, who said, if you buy a car and the brakes are faulty, then, you know, the manufacturer of the car is liable. Why do we accept systems which aren't secure? I think that was one of the most relevant remarks that we've heard. And finally, on TTIP, I am very much in favor of transatlantic free trade, or any free trade indeed. But of course, we cannot decide to a free trade agreement until the whole situation has been clarified and we have watertight guarantees for the rights and freedoms of our citizens. So I'm looking forward to further debates, and I hope that we're going to adopt a really strong package of recommendations in March. Thank you.
Thank you, Mrs. Intveld. Mr. Albrecht.
Thank you very much, Chair, and also thank you to the Rapporteur, who has presented a very good starting point for conclusions for our inquiry here in the European Parliament. It's now 6 months ago that the revelations of Edward Snowden showed us the ongoing meltdown of rule of law and the fundamental right to privacy and data protection, which is actually a human right in Europe. And I think it's very important to say that it's not this meltdown is not taking place because of Edward Snowden, and it's not taking place only since then. It's taking place because of the activities and the measures and legislations in place by our own governments. And Mr. Snowden has revealed it with great courage, and I think that we, first of all, should say this clearly in our report, and we should also call clearly for him to be acknowledged as what he is, a whistleblower, blowing the whistle on ongoing infringements, heavy infringements to the fundamental rights of all European citizens. And I think that should be worth a secure stay in a European member state, so that we can also hear him directly and his information. Secondly, I think that the points which have been made by the Rapporteur and also by the shadows on the importance of European data protection legislation and the framework agreement between the European Union and the United States to better protect the privacy and data protection rights of European citizens is central as a conclusion to this inquiry. It's important that our citizens get the control about their personal data. That's the best protection we can give them. But also, of course, we need control and oversight. And that means, I think, not only some blurry oversight, but clear parliamentary oversight, not only on the side of the USA, also here in the European Union. in our inquiry, we saw clearly that there is ongoing activity of our own European intelligence services, either on cooperation with the NSA or on their own, which is doing massive surveillance on our own citizens. And it should be clear that there's effective control in place. No control, by the way, is in place on the level of the European Union, because there's still the exclusion of national security completely. But we have heard also representatives of national parliaments, and I haven't had the impression that there is effective control in place on the national level. So we should fix that, and there should be rules on the cooperation and the work of intelligence services in Europe, European Union rules. So I think we should also draw that conclusion. By the way, there's also obviously no enforcement by police authorities or other authorities, competent authorities, cybersecurity or data protection authorities, when it comes to the cyber attacks launched by third states authorities or third state companies or companies based here in Europe on the servers and systems of telecommunications providers. I don't see why this is happening. Europol has again and again claimed that obviously there's no request by any national authority on the investigation even of these cyber attacks. I think this is ridiculous. That's a scandal. We have a lack of law enforcement, a huge lack of law enforcement, and we just passed our own cybercrime rules recently. We should be keen on enforcing it, and that should be part of our conclusions. And then let me say that this, of course, links also to the systems and to the security of systems. And Sophie Infeld just mentioned that this is a central part of liability, for example, for systems which provide the adequate safeguards we need in a digitalized society. I think that rather than breaking or subsidizing the breach of encryption and subsidizing surveillance measures more and more, we should invest in encryption powers, in anonymization systems, because we need to strengthen citizens and consumers to protect themselves if they want to communicate in private. Private communication, by the way, is also a human right. We should insist on that to be enforced, not only here in Europe, but also globally, that's clear. But we should walk ahead as a positive example, and I read with very much happiness that there's a clear reference to the necessity to end up with blanket retention of personal data without suspicion. But then please, let's spell out in detail that this means we need to talk about the data retention directive in the European Union, and we need to talk about those politicians still saying that the retention, the vast retention of passenger name records will solve our security problems. That's not the case. That's not the case, and anyway, it's not proportionate. It's blanket retention and breach of our fundamental rights. Last but not least, let me say that I think we really need to draw a line of what is acceptable to draw for either control or oversight of us all in societies when it comes to data, when it comes to communication. And we need to draw out clear lines what is not acceptable, and we also need to work on effective oversight mechanisms. And we need to do that as a European Parliament, no matter what our governments say, because obviously since 6 months they are not in the position and not capable to deal with these revelations properly, to draw the conclusions which we need. The European citizens are looking at this House, and there's elections coming up in May, and we want them to see that this House makes a difference. So please, let's go ahead. Thank you.
Thank you, Mr. Albrecht. Mrs. Ernst.
Ja, vielen Dank. Zunächst einmal möchte ich mich sehr herzlich bedanken beim Berichterstatter. Das ist sicherlich nicht nur notwendig, sondern auch berechtigt, eine so schwierige Problematik zu versuchen, unter einen Hut zu bekommen. Er hat sehr fair mit uns zusammengearbeitet, und ich denke auch, dass es in den kommenden Wochen und Monaten so sein wird. Wenn wir uns das Ganze insgesamt anschauen, dann muss man feststellen, dass wir es hier sicherlich mit einem der wichtigsten Berichte und der schwierigsten dieser Legislatur zu tun haben, aus verschiedenen Gründen. Und ich will das nochmal vor Augen halten. Es geht ja nicht nur um verlorenes Vertrauen. Das ist eine viel zu verkürzte Sicht auf die Problematik. Verloren gewordenes Vertrauen zwischen den USA und der Europäischen Union, uns als Bürgern, sondern es geht um tiefgreifende gesellschaftliche Fragen und viele Diskussionen, insbesondere mit den Whistleblowern, haben uns das deutlich gemacht, wie tief diese Problematik eigentlich angesiedelt ist, dass es um elementare Menschenrechte geht, um Freiheitsrechte wie Redefreiheit, Pressefreiheit, Kommunikationsfreiheit. Und man bräuchte eigentlich einen Bericht, der alle Ebenen zusammenfügt, also nicht nur die europäische. Wir haben ja nur einen begrenzten Ausschnitt der Untersuchung in den letzten Monaten durchführen können, sondern auch natürlich die Ebene der Mitgliedstaaten einbezieht. Und das passiert natürlich nicht, was nicht uns geschuldet ist, sondern der fehlenden Untersuchung, die es in den Mitgliedstaaten gibt. Und wenn heute die Information herausgegeben wurde, dass Frau Merkel dankenswerterweise von Herrn Obama zum Kaffeeklatsch eingeladen wurde, ist das alles sehr schön, das ist gut. Aber ich sehe natürlich keine Bewegung in unseren Ländern, in unseren Mitgliedstaaten, und deswegen muss es diesen Druck natürlich auch in die Richtung gehen. Der zweite Punkt ist, wir haben es natürlich auch mit Schwierigkeiten zu tun, die wir nur bedingt auch tatsächlich beeinflussen können. Das sind rechtliche Fragen, dass zum Beispiel mit Hinblick auf Nichtamerikaner wir natürlich faktisch einen Rechtsstatus in den USA haben zur Verteidigung eigener Rechte, der gegen Null geht. Also es gibt ein rechtliches Problem. Es gibt auch das Problem in der Richtung, was wir mit diesem Argument nationale Sicherheit im Einzelnen tatsächlich wollen und können auf europäischer Ebene. Alle wissen, interne Sicherheit, innere Sicherheit, äußere Sicherheit, wie weit kann man das hier berücksichtigen. In vielerlei Hinsicht, auch in den Mitgliedstaaten, ist die nationale Sicherheit, egal auf welchen Bezug man hier wählt, tatsächlich so eine Art Totschlagargument geworden, bestimmte Dinge nicht zu unterlassen. Und insofern haben wir es hier mit einem wirklich großen Problem zu tun bei der Untersuchung dieser Angelegenheit. Und der dritte Punkt ist, ich denke, man muss auch über die Antiterrorgesetzgebung sprechen, die in den letzten 10 Jahren stattgefunden hat, die natürlich ein Feld eröffnet hat, wo der Datenschutz gewissermaßen abgeschafft wurde und Fragen der Sicherheit über die der Freiheit deutlich gestellt wurden. Schauen wir uns den Bericht an, und das ist mein zweiter Punkt, dann will ich zunächst erstmal sagen, begrüßen wir ihn als GUE-NGL-Fraktion. Ich denke, dass er viele Dinge beinhaltet aus den letzten Diskussionen, die wir durchgeführt hatten in den Anhörungen, auch wenn uns sehr viel lieber ein Untersuchungsausschuss gewesen wäre. Aber unabhängig davon, glaube ich, ist sehr viel nicht nur zusammengetragen worden, sondern auch an Erkenntnissen und Empfehlungen, die wir auch unterstützen, hier zusammengeführt worden. Ich halte es für absolut richtig und unverzichtbar, dass Safe Harbor so nicht weitergeführt werden kann, sondern neu gestaltet werden muss. Das ist absolut unverzichtbar. Ich weiß nicht, mit welchen Argumenten wir eigentlich sonst kommen wollen, wenn wir nicht die Verträge, die wir haben, in Frage stellen, wenn sie denn verletzt werden. Und sie werden verletzt. Genauso sehe ich die Sachlage in Bezug auf SWIFT. Die Suspendierung muss bleiben. Das muss durchgesetzt werden. Unsere Position als Europäisches Parlament muss bleiben. Und es geht faktisch darum, das auch tatsächlich umzusetzen. Und alles, was wir bisher von der Kommission gehört haben in dieser Frage, ist absolut unzulänglich. Freihandelsabkommen. Es ist doch völlig albern, das größte Freihandelsabkommen der Welt abschließen zu wollen und diesen Aspekt irgendwie dort mit behandeln zu wollen, wenn dann vielleicht noch Zeit bleibt, wenn man vielleicht noch ein Blättchen übrig hat, auf das man dann irgendetwas schreiben kann. Ich glaube nicht an so etwas. Ich glaube nur, dass durch Druck, den man ausübt, und man übt Druck aus, indem man das Freihandelsabkommen auf Eis legt, nur so kann man zu bestimmten Ergebnissen gelangen und auch Fragen des Datenschutzes und vor allem auch der Freiheitsrechte besser umsetzen zu können. Wir brauchen das EU-US-Rahmenabkommen mit den USA in Bezug auf den Datenschutz Ich begrüße sehr den Schutz von Whistleblowern. Das spielt auch eine wichtige Rolle in diesem Bericht. Das muss gesetzlich gewährt werden und natürlich nicht nur von uns hier formuliert, sondern das muss eingehen natürlich auch im Grunde genommen in die Gesetzgebung der Mitgliedstaaten. Es ist mehrfach gesagt worden, technologische Unabhängigkeit Europas, das sei notwendig. Ja, da können wir gerne darüber diskutieren. Von mir aus können wir darüber diskutieren. Der Punkt ist nur, was ist unser Aspekt? Worauf setzen wir unsere Prioritäten? Und das können für meine Begriffe tatsächlich nur die Wahrung der Freiheitsrechte sein. Und insofern möchte ich erst mal über solche Fragen reden, bevor wir dann den nächsten Schritt tun. Was halten wir für schwierig? Ich will es ganz ehrlich sagen. Wir sind an einem Punkt angelangt in der politischen Diskussion, wo wir die Frage stellen müssen, welchen Sinn und Zweck erfüllen Geheimdienste oder Nachrichtendienste? Welchen Sinn und Zweck erfüllen sie? Wie ist die Angemessenheit ihrer Tätigkeit denn zu bewerten? Was sollen ihre Aufgaben sein? Welchen Sinn und Zweck hat Geheimdiplomatie? Wo ist sie denn wirklich notwendig? Es ist ja nichts hinterfragt worden in dieser Frage und das halte ich nicht für ausreichend. Die ganze Problematik der Geheimverträge unter den Nachrichtendiensten spielt natürlich auch eine große Rolle. Ein großer Punkt ist, das haben jetzt mehrere schon angesprochen, eine wirklich unabhängige Kontrolle von Nachrichtendiensten zu realisieren. Ja, wie wollen wir denn das machen? Es ist doch nicht das freundliche Gespräch mit einem Sachverständigen hier im Ausschuss. Wir brauchen eine Akteneinsicht, konkrete Möglichkeiten, die Kontrolle gewähren, und das muss vor allem auch in den Mitgliedstaaten gewährt werden. Insofern sehe ich hier eine Menge Löcher auch. Antiterrorgesetzgebung habe ich schon gesagt. Ein letzter Punkt, ich sage es mal ganz unumwunden, das Europäische Parlament muss eben einfach Geld in die Hand nehmen, mehr in die Hand nehmen, um die IT-Sicherheit hier im eigenen Haus zu gewähren. Was sind zwei große offene Fragen? Die will ich nicht vergessen hinzuzufügen. Reicht das alles aus? Das geht mir die ganze Zeit durch den Kopf. Treffen wir den Kern? Schaffen wir wirklich etwas, was Massenüberwachung in Frage stellt und tatsächlich auch möglicherweise dem abgeholfen werden kann? Das ist die Frage, die ich nicht beantwortet sehe. Und der zweite Punkt, was geschieht mit dem Bericht? Haben wir den Bericht geschrieben, schaut die Kommission drauf und sagt, schauen wir mal, gucken wir mal. Also ich glaube, wir müssen auch über Kompetenzen des Parlaments sprechen. Es kann nicht sein, wir sind keine Bittsteller, die sich hier in irgendeiner Weise in dieser Art artikulieren müssen. Wir brauchen mehr Kompetenzen auf diesem Feld, damit wir auch etwas durchsetzen können. Und das geht ohne die Mitgliedstaaten nicht. Danke.
Thank you, Mrs. Ernst. I think I was very generous with the shadow rapporteurs, and I have to be much more stricter with all the other members. I'm sorry. So I open the floor now for the colleagues who wish to intervene. I have 6 names: Mr. Pirker, Mrs. Ludford, Mrs. Gomez, Mrs. Sargentini, Mrs. Jimenez-Becerril, and Mr. Andrew. Anybody else? No? Then I close this list and I give the floor to Mr. Pirker, please.
Danke, Frau Vorsitzende. Zuerst einige kurze allgemeine Anmerkungen und dann einige präzise Anmerkungen, Forderungen und Fragen. Zum Ersten vielen herzlichen Dank auch an Claude Moraes für diesen sehr detaillierten und umfangreichen Bericht. Es ist insgesamt nach meinem Dafürhalten ein sehr interessanter Mix geworden. Auf der einen Seite eine sehr sachliche Analyse, wobei nicht nur Snowden und die Experten, die wir hier gehört haben, als Basis hergenommen werden können, sondern Basis sind auch die Aussagen, die wir direkt in den USA eingeholt haben, Aussagen von Congressmen, von Senatoren, die auch einbekannt haben, dass eben das US-Recht nicht immer eingehalten wird, sondern teilweise ignoriert wird. Das Zweite, es gibt sehr berechtigte Kritik, die hier geäußert wird, mit einer sehr scharfen Wortwahl, zugegebenermaßen manchmal, würde ich sagen, etwas überzogen oder martialisch. Es sind unerfüllbare Wünsche auch einformuliert, wie zum Beispiel in der Ziffer 21, wo eben die Mitgliedstaaten aufgefordert werden, Überwachungstätigkeiten von Drittstaaten auf ihrem Gebiet nicht zu erlauben. Ich weise auf den Punkt deshalb hin, weil wir bei solchen Forderungen Gefahr laufen, als naiv angesehen zu werden. So etwas kann ganz einfach nicht realisiert werden. Deshalb sollten wir uns solche Überlegungen auch überlegen und nach Möglichkeit gar nicht stellen. Es sind Forderungen enthalten, die auch vielleicht nicht gestellt werden sollten, und zwar dann nicht, wenn der Datenaustausch im beiderseitigem Interesse erfolgt und die Regeln, die wir uns gegeben haben und die Verträge auch tatsächlich eingehalten werden, wenn zum Beispiel klargestellt ist, dass der Bankdatenaustausch, SWIFT-Abkommen eingehalten wird, so ist das im beiderseitigen Interesse und dann würde ich es, weil eben funktionstüchtig, nicht in Frage stellen. Und jetzt komme ich zum wesentlichen Punkt. Es sind viele sehr berechtigte und absolut notwendige Forderungen drinnen, mit dem Ziel, das Vertrauen wiederherzustellen im Interesse der funktionierenden Wirtschaftskooperation, der funktionierenden Sicherheitskooperation EU-USA und als zweites Ziel, dass wir auch Maßnahmen setzen zur Abwehr und zum Schutz der europäischen Interessen, sprich der Bürger und der europäischen Wirtschaft. Ich nehme 4 Forderungen heraus. Das erste ist, dass alle unterstützen, dass wir gleiches Recht auf amerikanischem Boden haben für EU-Bürger wie für US-Bürger. Das zweite ist, dass wir das Datenschutzrahmenabkommen realisieren. Das dritte und für mich ganz wesentliche ist, dass wir viel klarer noch, als im Bericht hervorgeht, ansprechen, dass Europa eine eigene Spionageabwehr braucht. Wir brauchen keinen eigenen Geheimdienst, wie der manchmal von der Kommission vorgeschlagen wird, aber eine Spionageabwehr, um die wirtschaftlichen Interessen der Europäischen Union vor fremden Zugriffen welcher Staaten auch immer abzusichern und abzuschützen. Alles natürlich unter genauen Regeln, unter Kontrolle, auch unter parlamentarischer Kontrolle. Ich würde bitten, das so hineinzunehmen, wie wir das ursprünglich bei Europol hatten, die Kooperation der Abwehrdienste der Mitgliedstaaten mit einem multilateralen Abkommen. Wir brauchen dazu keine Vertragsänderung, sondern das kann rasch realisiert werden, Regeln festzulegen, die die Sicherheit des Datenaustausches der Dienste erstens sichern und zweitens kontrollierbar machen. Hier hat Moraes in den Punkten 65, 66 einiges angedeutet, aber ich würde bitten, das in diese Richtung zu präzisieren. Das würde auch den Zwang in den Mitgliedstaaten erhöhen, die Dienste besser zu koordinieren, als das bisher der Fall ist. Und der letzte Punkt ist, dass im IT-Bereich einfach die europäische Unabhängigkeit verbessert wird. Hier haben wir einen dramatischen Aufholbedarf. Haben wir Server angeboten, haben wir europäische Clouds angeboten, dann haben wir auch die Möglichkeit, den Datenaustausch nach europäischen Regeln zu kontrollieren und im Interesse der Bürger sicherzustellen. Danke.
Thank you, Mr. Pirker. Mrs. Latford, please.
Thank you very much, Madam Chairman. I'm afraid I'm going to be rude and make my comments and then I have to run. I apologise to colleagues for that. Pick up on something that Sophie said about not being in favour of putting a fence around the internet in Europe, which I utterly agree with. Therefore, I'm a bit worried with the use of the term independence in Europe. I'm all in favour of putting extra resources into the development of European cloud services and IT services generally, but I wouldn't want any kind of balkanisation. And so I'm a little bit wary of that word, that term, in independence, which, echoes Vice President Reding has used that term, and I personally don't find it terribly helpful. Then I do find a little bit of a contradiction in the report. I very much agree that the consent, Parliament's consent for TTIP will depend on a lot of things, but one of them will be the trust in the online environment, transatlantic online environment. Although, of course, we always have to remember that it's not just the US which wants TTIP; it's Europe as well. But I do find it a little surprising to call now for the suspension of safe harbour when in recitals Y and Z there appears to be a relatively favourable reference to the fact that the Commission has addressed 13 recommendations to the US and engaged to identify with them by summer 2014 the remedies to be implemented as soon as possible and providing the basis for a full review on safe harbour. And then there's reference in Z to how the FTC has admitted that safe harbour could be reviewed in order to improve it. So now, obviously, it depends when you're going to actually get any assurances and real safeguards and guarantees. But I just find it a little bit contradictory to note, apparently with approval, that there's a process going on to try and strengthen safe harbour, and yet call for suspension now. And I admit that as Vice Chair of the US delegation, I'm very keen on making a common economic space, not naively, not ignoring all the challenges and not least on the online environment. But I just a bit uncomfortable with the apparent contradiction there. Suspend safe harbour now, but of course there's an ongoing process to review it and hopefully strengthen and improve it. And I'm a bit uncomfortable with that.
Thank you, Mrs. Ludford. Mr. Moraes, you wanted to answer something before Sarah Ludford leaves. Yes.
Kinga, thank you very much. I'm sorry to take up time. Just that before Mrs. Ludford leaves, and also to Sophie Intervelt, the point on cloud computing, both in my remarks and indeed in the text of the report, I don't think it's very clear the way that I expressed the cloud computing point. I think it needs to be clarified, the fencing in and the way that it's been expressed on independence. I'm not a fan of fencing off our European cloud. In fact, I'm quite opposed to that, and I've said that in the past. So we would need to change the language on that. And I want to make that very clear to an external audience that's watching, as well as to my two colleagues, and I want to say that now before Mrs. Ludford leaves. So if you would allow me to do that, thank you very much.
Thank you, Mr. Moraes. And now the next, Mrs. Gomez, please.
Madam Chair, I'd like as well to thank Claude Moraes for the very intense and high-quality report that he presented to us as a result of all the auditions we have conducted and all the contacts we have made. It's really an excellent basis of work. More than that, and as a co-rapporteur on AFET's opinion, I'm very grateful as well for the way we have indeed cooperated, as Mr. Salafranca and Claude Moraes himself have highlighted. I think indeed this is about shared values among EU members, shared values with the US. And I think this is even more important for people who, like myself, come from former totalitarian states. I lived 21 years under dictatorship. So it's really not just about the rule of the law, the respect for the privacy of the citizens. It's also about the effectiveness in fighting terrorism, and that I firmly believe cannot be achieved if we resort to the same methodology of terrorists, undemocratic and unlawful methodology. That simply is not an effective way to fight terrorism, is to actually reinforcing the hands of terrorism. It's becoming ourselves terrorists. So I think indeed that the role of Edward Snowden should be highlighted, because his disclosures have been very important, not just to give the information about the way the privacy of citizens in the EU, but in the US, all over the world, is massively being violated, as well as how that is being perverted for Orwellian and not so Orwellian purposes, namely in terms of espionage, political, economical, and so on. And even more important, the way he has shown that indeed tools that are designed to fight terrorism are not effective. Because if the mass surveillance system that NSA has implemented with the pretext of fighting terrorism has indeed been putting a lot of efforts and resources in massive surveillance of citizens from all over the world, and has allowed it, for instance, 2 Chechen guys who blew up the Boston Marathon, on whom there was clear, direct intelligence that was neglected. It actually shows how there is inefficiency in the fight against terrorism. So I think, indeed, this is an element that should also be here reflected, and it is in many ways. I believe that, as it has been said, we have strong data protection in the EU, but we do not implement it. We have a real problem of enforcement, as Sophie in Veltin said. And that we cannot blame the US, we have to blame our own agencies and our own institutions who do not perform their role of oversight, political, judicial, whatever, when there is the opportunity. And we have seen the case of Belgacom that points out, of course, it might be ultimately as well a US responsibility, but it is a European member responsibility. And of course, in the case of Belgacom, it was obviously directed not just at, irrelevant European parliamentary members, but there are guys like Mr. Barroso, Mr. Barnier, Mrs. Reding, who do an important job that is probably interested to be spied upon by others. So, I mean, I note, for instance, that now in the US there is a debate whether NSA is not denying they have been spying Congress members. And I remember when we were in the US, I was going around asking what more when they were telling us that they were terrified with what was still to come from Edward Snowden. I said, what else worse can come out? Because at that point we already knew about the spying on Merkel. Only spying on Obama himself. And interestingly, nobody denied that. Nobody said, oh no. So I think we are here talking about the essence of the rule of the law and of our democratic states. Finally, I would just like to say that I share what others' concerns about the phrase on Article 59 on TTIP. I think we can formulate the sentence better, because actually what I want, it's about building trust, as others have said, but the most essential thing is indeed, in my opinion, is to have the US act in a way to help us build that trust. And the most essential thing, in my opinion, is what concerns the umbrella agreement, the framework agreement. Because how can we have a minimum trust if we don't have the basic right to redress judicial and administrative to EU citizens in the US? And finally, I will only stress, indeed, the question of oversight responsibilities is crucial, and it's not just the job for national parliaments and national authorities. If they don't do their job, I think we could and we should point at a reversal of the subsidiarity principle. If they don't do their job, as obviously many of them don't do, it is the case in my country, Portugal, then it should be this Parliament who should indeed make sure that the laws and the procedures, even in member states, ought to be reviewed.
Thank you, Mrs. Gomez. Mrs. Jiménez Becerril.
Muchísimas gracias, señor presidente. Ante todo, quería felicitar al ponente, Claude Moraes, con quien tuve la ocasión de trabajar en Washington en nuestra visita. Creo que ya pudimos comprobar in situ cómo es un tema que preocupa no solo a la opinión pública europea, sino mucho también a la opinión pública americana con respecto a Europa, cosa que es ya de agradecer, porque normalmente no suelen interesarse mucho por nuestros temas, pero en este caso sí lo hicieron. Allí tuvimos ocasión de exponer todos los temas que preocupan en este Parlamento como representantes de los ciudadanos. Creo que ellos están muy preocupados nuestros ciudadanos están muy preocupados por la privacidad, pero no menos también por su seguridad. Y, por tanto, creo que debemos ser muy cautos a la hora de tratar todo lo que tiene que ver con el terrorismo. Creo que es absolutamente intolerable, son intolerables estos espionajes masivos, hablando de derechos humanos, pero esto no puede traer como consecuencia inmediata la suspensión de los programas sobre colaboración en la lucha antiterrorista. Creo que SWIFT no tiene absolutamente por qué ser el chivo expiatorio de este escándalo, repito, intolerable. Creo que SWIFT no está relacionado directamente con este espionaje masivo y es de todos conocido que hasta hoy ha funcionado correctamente. De hecho, en nuestra visita a Washington, y Claude Moraes lo puede corroborar, comprobamos cómo nos explicaron cómo había sido efectivo en casos de suma peligrosidad. Por desgracia, los éxitos en materia antiterrorista no pueden gozar de publicidad por motivos obvios. Y existen muchísimos atentados, cientos de atentados abortados que posiblemente ni la señora Gómez ni yo conozcamos. Además, conocemos, sabe también, concuerdo con el ponente, la sombra Axel Voss, que la idea tenemos que potenciar nuestras agencias como Europol, NISA, y para poder avanzar en una inteligencia europea común, para así ganar independencia a nivel europeo y poder colaborar más equilibradamente con Estados Unidos. Creo que lo importante es el mensaje que se está dando a los ciudadanos sobre este Parlamento. Concuerdo, como ha dicho la señora Inbel, que somos los únicos y los que más nos estamos moviendo y eso es algo muy importante. Y desde luego no considero responsable, tenemos que lanzar un mensaje de responsabilidad y no considero que seríamos responsables con la suspensión de SWIFT, porque eso solo lo aplaudirían quienes financian el terrorismo y, en resumidas cuentas, los terroristas. En líneas generales, apoyo este texto, pero como ya he expresado, tengo algunas reservas. Muchísimas gracias.
Thank you very much. Mr. Enciu.
Mulțumesc, doamnă președinte. În primul rând, aș dori și eu să-l felicit pe Claude pentru proiectul de raport prezentat și pentru faptul că a dovedit o capacitate de muncă și o tenacitate care o consider greu de egalat. Sunt întru totul de acord cu concluziile și recomandările propuse de către raport, dar eu cred că în momentul în care acesta va fi aprobat cu completările de rigoare, cel mai important va fi ca Parlamentul European să se mobilizeze ca să impună aceste modalități clare și controlabile democratic prin care să se prevină în viitor supravegherea în masă. Eu cred că astfel se va crea și această mult discutată balanță între lupta împotriva terorismului și abuzurile de care s-au făcut până acum. Aș vrea și eu, foarte scurt, să dau un exemplu, să zic așa, drăguț, legat de supraveghere, care s-a întâmplat în România zilele trecute, și anume contul personal al directorului general al Serviciului Român de Informație a fost spart de către un hacker, ceea ce dovedește că serviciile secrete ar trebui să mobilizeze poate mai mult pe crearea unor sisteme de protecție și prevenire decât pe crearea unor sisteme de supraveghere. Vă mulțumesc.
Thank you. And now I give back the floor to the rapporteur. Please try to be very brief if it's possible.
Okay, Kinga, I will be brief. I'll be really brief. How brief do you want me to be? Very, very brief. To be honest, I think what I said at the beginning of the session was that there is a high level of expertise amongst members, and those members who are not specialists in data protection as I wasn't. I have an expertise in many areas of justice and home affairs in my background, but not in data protection. And again, it's reflected here too, where we have members who are experts in privacy matters and data protection matters, but also we have members here who are experts in other fields, and you can see that in the contribution. So I won't attempt to answer questions with their permission where they were self-standing comments. But I'll very briefly just pick up on really points where, for example, colleagues have asked me to answer on the record really quickly their questions. I mean, very quickly, both Teresa and Mr. Perker, so that I'm not accused of not answering these key questions, raised the issue of intelligence gathering and also the issue of SWIFT. I want to very openly say that there will be elements of the report, of course. This is a draft report, and we have now had a legacy of intense activity on issues like SWIFT, on Safe Harbour and so on. We've had many resolutions, Commission statements and so on, where we have had some political differences between our groups. And of course this will be reflected in the report also. But I want colleagues to understand that I understand the nuances and differences very much. This doesn't mean that I don't understand the worth of SWIFT intrinsically as an operation. We, of course, negotiated that agreement. I was there at the time. What we have to do in the report is look at the allegations themselves. But of course, within our political groups, we may have differences on what ends up being in the report, and this is why we have this amendment period. So I do want to acknowledge that there will be some of those differences. What I hope will happen, and now I refer to the Foreign Affairs paragraphs too, where Mr. Salafranca mentioned there may be some amendments to, and Mrs. Gomez, I think, referred to that too in our shadow meetings, is that where there may be amendments, I hope that it will not, in the end, change the emphasis of the report, which will be what was the thrust coming from the shadows, who I know it's commonplace, and I promise I'm not going to take up much time, to thank the shadows, but here the shadows created this report because they produced working documents. This is the methodology we pursued, and what I'm hoping is that if you look at this report, and here I want to also put on record my thanks to the entire Secretariat who put so much work in, is that they have produced, if you look at pages 30, I think it's 32 and 33, European Digital Habeas Corpus, something really special, which is in answer to Mrs. Ernst. Is Cornelia still here? Is she still here? No. Okay, people are starting to go, so I really will speed up. She talked about what happens to this report, is it just going to be thrown away kind of thing. There is a blow-by-blow timetable picking up on when the recommendations can happen and how this report will be taken forward. And I know time is short, so I just want to make this point. What is happening in this report and how the questions have developed are in relation to two types of issues that we've looked at in this. And because I'm not an expert on data protection, as some of my colleagues are, I've noticed two things. One area where we have EU competence, clear competence, and some areas where we have real moral or political responsibility. So in oversight, where there is national responsibility, we have real moral and political responsibility because we are from those member states. And maybe our citizens are saying, what are we doing on this? What's our involvement? But we have EU competence in some of the negotiated areas, so Safe Harbour, SWIFT and so on, TTIP and so on. And what I've noticed is that we're expected to then react to all of these things. And what I think is good about this report and where the work has gone in is in looking at this European digital habeas corpus, a way of saying to the next mandate, to the Commission, but also to the Member States, no, we won't ignore oversight with the Member States. We will convene a conference to look at the oversight mechanisms of Member States. We won't abdicate that responsibility. We won't pretend it's our competence, but we will address it. We will have a timetable for it. And then when it comes to those hardcore areas where we have clear competence, Safe Harbour, SWIFT, even where there are differences of opinion, we will enter that territory and we will make a clear recommendation. And then, of course, in the amendment stage, we may have political differences. So I hope this report will understand that we are a serious Parliament. And I just end on this. I read this week in The Economist, the Lexington column of The Economist, which is the one written by the Washington correspondent. He mentioned that the European Parliament was good at indignation, which I thought was really interesting. He admitted that the European Parliament was dealing seriously with this issue, but then he said, we're always good at indignation. Well, I really believe, and I echo what Mrs. Intervelt said at the beginning, that I feel very proud that there are members in this Parliament, some of whom went to Washington, those who have gone through all of these very difficult, more than 15 hearings, and then those shadows who contributed to this report. I've never seen such a process where the Secretariat were so heavily involved as well, where we have tried to make out of a very difficult, nebulous process and try to then make it into a serious detailed process at the end. And I think this report does reflect that. So I'm very happy that we've tried to do that at the end and not just have indignation, but something serious in terms of recommendations with a timetable. So I hope members will see that when they start to amend the report, and that we do support it eventually in February in committee and in March. And I look forward to seeing the amendments, and I look forward to that cooperative period in the next couple of weeks. Thank you very much. And thank you, Kinga, for your cooperation.
Thank you, Claude. Now I have to announce the deadline for tabling amendments is the 22nd of January, 6 o'clock in the afternoon. And thank you all, colleagues, for your cooperation and involvement. And now I go to the last point on our agenda for this afternoon and for this meeting is a presentation of the draft opinion by Mr. Salvador Cedo y Alabar to the draft report of ITRA committee, where the rapporteur is Mrs. Pilar del Castillo, on the proposal for a regulation of the European Parliament and the Council laying down measures concerning the European single market for electronic communications and to achieve a connected continent. I will give immediately the floor to the rapporteur, Mr. Cedo y Alabar. Please.
Thank you, Chairwoman. I will be very brief, especially after this interesting and important debate about the document of Mr. Moraes. I have the opportunity to be also in the LIBE delegation in Washington, and some of the debates has been used in order to prepare this draft opinion in the important document preparing for this internal European single market for electronic communication. Moving towards the truly single and competitive market for electronic communication services is an European Union priority. In doing so, we need, however, to enhance consumers' confidence by respecting their rights to privacy, confidentiality of their communication, and protection of their personal information. In this regard, I welcome the Commission's effort to facilitate the harmonization of end-user rights. Adhering to the rights to confidentiality of communications, privacy and personal data is a key part of building consumer trust and confidence in the EU electronic communication, and thus its success. End users need to be certain that these rights are respected whenever they make use of electronic communication services and networks, and that any interference with these rights is proportionate and necessary to achieve a clearly specified legitimate purpose. The present opinion, therefore, focuses on those aspects of the proposal which are likely to have an impact on the rights to privacy and the protection of personal data, as well as on the confidentiality of communication, basically the Chapter 3, part of the Chapter 3 and the Chapter 4 of the proposal of the Commission. Any measures allowed under the proposal that interfere with end-user data protection and privacy rights should be subject to transparency, strict proportionality and necessity limitations. The amendments proposed aim to guarantee confidentiality of communications, privacy and personal data protection in order to build consumer trust. I look forward to a fruitful discussion on how to better protect user rights in a connected continent. Thank you very much.
Thank you very much. I will turn now to the Commission. Mrs. Vesa Terava would like to take the floor.
Thank you, Madam Chair. I will be very brief. First of all, the Commission certainly agrees with the rapporteur that the confidentiality of communication and the protection of privacy and personal data are key in order to build consumer trust and confidence in a digital single market. And the Commission has indeed paid due attention to these issues in its proposal. So I think we are very much in line with the thinking of the rapporteur. Maybe just a few comments of a technical nature on the amendments we have seen in the report. First of all, there seems to be a bit of maybe misunderstanding about the traffic management and what is needed to manage the traffic, and there's, the way we read the amendments, we believe that there's an expectation that you always need to apply inspection techniques to manage the traffic, and this is not clearly the case, and it's therefore the Commission in its proposal, for instance, has not specifically mentioned any inspection techniques, because we want to be technologically neutral and set out the basic principles. So in this respect, some of the amendments maybe are, although they have the objective which we share, they may be a bit misleadingly formulated. Maybe then another more general comment. The reference the rapporteur has made to the relevant EU legislation on privacy and personal data. Of course, as such, we do not have problems, but of course part of this legislation, in particular on data protection, is currently under review, and it may be more sort of future-proof to make these references in a more general terms. Of course, the Connected Continent proposal is without prejudice to any EU law on privacy and the protection of personal data. Thank you very much, Madam Chair.
Thank you very much, Mr. Terava. I turn back to the rapporteur, whether you would like to add something.
Just to comment about the question of the inspection. We have contact with different groups and different people, and this is something that people are worried. But of course, in the process of amendments, I think that we can find a better way and discuss about the Commission, especially if some of these amendments cannot be well understood in the idea that I like to present. And especially on the question of data protection, we were very aware about the proceedings and the directive on data protection, or the data protection package that this Parliament is discussing in order to include in the general provision the data protection package. I'm sure that with the rest of the group we will have find a common position in this important package to send the opinion to ITRE committee and to be discussed there. Thank you.
Thank you very much. The deadline for amendments for this opinion is foreseen for Thursday, 16th January at 6 o'clock in the afternoon, and a vote in our committee for the 12th or 13th of February. So thank you very much. And the last announcement, the next meeting, the next LIBE meeting will be next Monday, 13th of January in Strasbourg. We will have very important votes, so we count on our colleagues. Thank you very much for your cooperation, and I wish you a nice afternoon and a very good weekend. See you next week in Strasbourg.